Good day, liberators and fellow South Africans. Again, we've got very good news to share with all of you. During this last week, we've received confirmation from the African Commission on Human and People's Rights that one of our cases relating to judicial corruption submitted to them way back in September 2019, so it was pre-lockdown period already, has finally been seized by them during their 69th ordinary session held last year, December. Now, unfortunately, there was a bona fide error in some of the documentation sent to us to confirm the seizure, and we wanted to get clarification from the secretary of the commission, and it took literally almost 4 months to get that confirmation, and finally we've received it. At last, we've received it, and we've got 2 months to submit our evidence. And what it means is that the African Commission will investigate these allegations of judicial corruption. Now, in summary, let me explain to you what this case was all about, and because it relates to judicial corruption, and this is the second case now that we have now allowed to be seized by the African Commission relating to judicial corruption. So, Mr. Zondo, just last week you've made a big statement in the media once again to say that the judiciary has not been captured and there's nothing wrong with the judiciary. They're not corrupt. Blah 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 blah. The whole story. Mr. Zondo, you're going to have to explain to the African Commission that the evidence that we're going to put before them does not relate to corruption, and we are sure that we have exposed, especially the Constitutional Court. Leave it as it may. I'm not going to mention the name of this member of ours to protect his identity, but to make a long story short, this member of ours have developed a special equipment for the arms industry. He sold his license to a large arms manufacturer. There was a proper contract engaged in, and this equipment would have then been put into these armored vehicles that they produce, and he will then get paid as they get paid for orders that they produce. Eventually, this arms manufacturer didn't want to pay him, and it led to arbitration proceedings. The contract made provision for that all disputes had to be referred to arbitration first. Eventually, they didn't want to participate in the arbitration process and then said, well, it has lapsed. The matter was escalated to the High Court. The member of ours did not have any further money to pay to his legal team, so he had to do all the things himself. So the first hurdle that he had to overcome was the fact that the court didn't want to allow him to represent his own company, although he was the sole shareholder and the sole director of the company. So he had to apply to represent his company, and when he came before this certain judge, she just basically, without proper putting her mind to the matter, she dismissed his representation application to say that he may not represent his own company, of which he was the alter ego. And strangely enough, she made an order that he had to be joined as a party to the proceedings, so that a cost order could have been given against him. So the same argument that was used to add him, to join him, and she confirmed that he was the alter ego, so that is why he had to be mauled with the costs in person. That's the very same argument had to be provided, or was relevant also, in his own representation application to say that he was the alter ego of his own company. So he said that the judge treated him very bad, and he submitted a complaint to the Judicial Service Commission. The Judicial Service Commission, of which Mr. Zondo himself was also part of, dismissed the complaint to say that, well, the matter can be appealed and then rectified later. But they never addressed the behavior of the certain judge. So eventually we filed, and we've assisted him to file an application for leave to appeal, and that was also the first time that a judge recognized the friend of Mackenzie principle in our law as well, whereby I was allowed to sit next to our member and assist him as a lay litigant. So it did come out as a very positive judgment in that respect. However, the leave to appeal was dismissed. He later on tried to appeal to the Supreme Court of Appeal. That was also ignored. He had always good reasons. Then he escalated it to the Constitutional Court, and the Constitutional Court, inclusive of the erstwhile Chief Justice Mogoeng Mogoeng, a full court of 9 judges or so, all of them unanimously confirmed that he did not have any prospect of success and just simply dismissed his application for leave to appeal and direct access. So then we have escalated it to the African Commission on the grounds that the judiciary of South Africa treated him in an inhumane way. He was refused proper access to our courts. His rights as a citizen was violated in the process because our courts did not adjudicate it properly and as it should have. And people, when anyone who has got 2 brain cells as a law expert can determine that this member of ours did have a proper and a very good argument to succeed. And what this have led to is that the company that signed a contract with him, a license with him to utilize his equipment that he developed, continued using it for their own gain. And they've made millions, if not billions, out of it up till now. So what we are saying now is that the South African government, because of the judiciary who have been corrupt and totally violating his human rights, have now it resulted in damage to him, and we have entered a damage claim for more than $1 billion American against the government of South Africa in the process. So we will keep you up to date with proceedings in the African Union. This is great for us because now there are 2 cases, as I've said in the beginning, where the government of South Africa's judiciary is taken to the stand and they need to explain themselves. We are 100% sure that the Constitutional Court and the Supreme Court of Appeal are utilizing gatekeeping services to selectively let through certain cases that's important or for the elite, and many of the good cases deserving hearings before the Constitutional Court are simply discarded, like our own challenge of the national state of disaster, where it turned out that one of our arguments, as I have reported before or recently, have now been confirmed to have been correct. So the whole practice and the whole system of appeal and going to challenge our constitutional rights are now on the board. We want the African Commission to see how we as the people have been treated by our judiciary. Many of us don't have the luxury of affording expensive senior counsel like the government always do and all these big shot companies have. And we are then forced to try and pay what we've got to legal eagles. And at the end of the day, they're just taking our money. And hence the reason why the moment when we come in and start representing ourselves to say the hell with the legal fraternity and the judiciary of South Africa, we will do it ourselves because we've got a very good case, then we are being lambasted. So people, as I said, we're going to keep you up to date. This is very exciting news. Please remember to subscribe to our channel, like this video, share this video with others. Others need to know what is going on in our country, and also they need positive feedback. This is positive. And also remember that if you want some more and would like to assist in voluntary donate to our work, please join our YouTube channel. Part of that money, 70% of that money, are going directly to us, and then we've got fixed income at the end of the day from all the membership to fund our work. We've got other positive things to also report back sooner than later. So keep tight, look at this space, keep this space reserved, and I'm back. God bless. Until the next time.